rise. The Court of Appeals Division 1 is now in session.
Please be seated. All right, the court now calls case number CV130750, Flood versus Paloma. This is the time set for oral argument. Counsel, let me advise you, as you probably well know, these proceedings are being audio and video recorded, and the proceedings will be available on the court's website in a few days. I want you to be aware of that fact, that there's going to be a video of these proceedings on our website. When you come up and you begin your argument, if you would, please identify yourself and your client. You both have 20 minutes. Appellant, you may reserve 5 minutes if you wish to do so, or whatever time you think is necessary. I would advise you, of course, that we've read the briefs, we've conferenced the case, we're very familiar with the issues. The clock in front of you will keep track of time for you. So, counsel for appellant, you may proceed. Is it Mr. Helm?
Yes, thank you, Your Honor. My name is John Helm. I'm here representing the Flood Control District of Maricopa County in this matter. I have just a few things I'd like to talk about in my opening and answer any questions that you have, and then reserve whatever time I have left for rebuttal. First issue that I'd like to talk about is the mootness issue that's raised in the appellee's brief. As I understand it, the law that governs mootness requires that the requested decision by the court have no practical effect on the parties, and if that's the case, then the case is moot. We would suggest to you that in this matter, that's not the case. There's a substantial amount of money involved in this issue. If the county prevails on the request to you, it will receive a substantial amount of money, and the appellees will have to pay a substantial amount of money. So we would suggest that there is a real practical effect on the parties if we prevail, and therefore the case is not moot. Along that line, Arpaio is the newest case that I'm familiar with, Arpaio versus the Maricopa County, and so you may understand why I'm a little familiar with it. And in that case, it had some additional issues that needed to be cured for a case not to be moot. Those included was the payment that was made part of a compromise and settlement. In this case, it's not. The next question they had was the payment part of an agreement not to appeal? In this case, that's not the case. And finally, did the appellant receive any benefits and accept them from the judgment? In this case, there's been 2 judgments entered, and we haven't had one benefit from any of them as we stand here today. The next item that I'd like to talk about is the argument that the appellees make about the tender of funds not being designated, and that's a requirement if we're going to go forward with this. We would suggest to you that we honestly don't understand how they can make that argument, but they do. If you look at what transpired on the morning that the funds were sent to them, it's perfectly clear that they knew that we, the defendants, were tendering them under a designation of how we wanted them applied. If you take a look at the emails that were sent on that morning, the first one starts out, and it's addressed to everybody, and it says, we're transferring a bunch of funds. Here's how they're being transferred. $14 million plus to the Knurk Trust Fund, $9 million plus to the Mesh Trust Fund. Then you go down a paragraph and you see that we lay out how they're to be applied. The email sets, the Knurk transfer represents payment of the principal amount due to the farmers. Then it goes down to the Mesh account, and it says, the Mesh transfer represents payment of the principal to Hartford and Prudential. Both of those statements then go on to tell the appellees what the interest rate is we applied, 4.25%. The mesh statement has a few additional comments regarding an $80,000 attorney's fee bill, $424 in costs, and it also has a comment where we lay out what we're not paying and that there's $27,000 and change that we're not paying. Finally, in that first email, it advises them that the purpose of the payment is to cut off the accrual of interest. Now, I don't know what more a person could do making a voluntary payment. In other words, a debtor making a voluntary payment could do to tell them, here's how we want the funds applied. It's pretty clear that we want to pay the judgment because if we don't, we obviously aren't going to stop the accrual of interest. There's never been a way known to mankind to avoid interest without paying principal, or if there was, I wish somebody tell me how to do it because I'd be the first guy in line if they did. You look at the end of this email, and it tells them again, what are we doing here? We're attempting to cut off accrual of interest, so we're making these payments. So they had all the information they needed that morning when the transfers were made, how we wanted them designated. If you go on and look at the rest of the email transactions that went by that morning, you can see that in every one, they're told the purpose of it is to cut off the accrual of interest.
Well, I have a question for
Sure.
you on that. How does it cut off the accrual of interest? This is post-judgment interest, right? So there's a judgment that has principal and interest, so you pay off the principal, but there's still a portion of the judgment that's the interest that's accrued. Don't you still have to pay post-judgment interest on the
Not if the
interest
judgment's
portion of
paid.
it?
Pardon me. Not if the judgment's paid. In other words, we're paying the principal, all right? This case does not involve just only post-judgment interest.
Paying the entire judgment.
If you're paying the principal, go back to the theory, what's the purpose of interest on a judgment? The purpose of interest on a judgment is to compensate the person who's looking for the money for not having the use of that money. When we give you the use of the money, the reason for the interest goes away.
I understand that, but I guess what I'm asking you is the issue what defines what you would have to still pay or not is the interest rate, right? If you're correct on the interest rate, then you've paid off the whole amount of the judgment. If you're wrong, then you still have accruing interest on unpaid interest,
Well,
even if you've designated the money to the principal.
At that point, what you're doing is you're requiring us to pay interest on interest.
Well, but it's part of the judgment.
Well, it's part of the judgment, but it's only interest, and it's only and what's the interest supposed to do? It's supposed to pay you for losing the principal. You got the principal back. There's no justification for the.
But isn't it interest on the accrued interest as of the time you made the payment?
Well, what you're saying is if we don't pay, if the interest really accrued at 10% instead of the 4% that it should have, what we're doing is we're paying interest on it. That's compound, right? By anybody's definition, that's compound. If you look at, I think it's McBride, but it's cited in our brief. It says it's not compound interest you get on a judgment. You get simple interest. So there's nothing more to accrue. It's all done. So in our view, once you pay the principal, you don't get to claim that the interest continues to run or that you get paid interest on interest. Your damage is over.
In any event, if we agreed with you as to the interest rate, we wouldn't get to the question of how to allocate the payments. Is that correct? If you're right about what the interest rate is, it doesn't matter how it's allocated. Isn't that right?
It's a full payment at that point.
Yes.
Absolutely, yes. Yeah. I'm sorry, I didn't understand you for a second, Your Honor. That's correct. You don't have to reach it. The deal was over. We get the difference back, and we go home, and they go home.
Well, I think this is the third appeal. You might go home.
We're hoping we do, Your Honor. I'm getting a little gray up here, and I'm worried that this may at least be my last appeal, or at least I'm a little hopeful of it. I like to go out and do a little fishing and enjoy myself. And that's not to mean that I don't enjoy myself when I'm here talking to you, gentlemen.
I was going to say, you've always enjoyed yourself.
the calculation that we've just been talking about, the other thing I think I should note to you is Judge Verdon realized that calculation was correct. And the only reason that she didn't give it to us was because she thought they ought to get 10% interest instead of the 4.5% that the statute provided. Now, that's all discussed in our brief, but I think it's appropriate to recognize that what the appellees want is they don't want that new interest rate to apply to us. And the reason that they don't want it to apply, they say, is because, wait a minute, in the session laws, there's Section 17B that says it doesn't apply because it only applies to cases that are adopted on or after the effective date of the change in the session law. We don't think that's a very consistent approach because, one, they only want to apply part of the statute to themselves, the part that gets them out from under. They don't want to deal with the statute in its new form, which, if you look back at McBride, which is adopted in 1981, it's over a 30-year-old case. It's been good law ever since. They would have to, because McBride says that when the interest rate changes, the interest rate on the existing judgments change. There's an interesting argument to be made in this, and we feel, let me put it right up front, we think there needs to be some statutory construction done here. We think what they're arguing is an inconsistent interpretation of the statute that was adopted in 2011 to modify 44-1201. We think that needs to be worked out if you're going to go that far. And it seems to us that if you went through the timing series, we have McBride in 81, in 2009, a judgment's entered against the district, and in 2011 we have a change in the statute. That change in the statute changes the interest rate, and it lowers it. And the reason it was changed was because the legislature at least thought that it was getting too expensive for litigants to come to see you folks. That to put a supersedious bond up was getting out of control, and that they needed to put some caps on some of these things. And one of the ways they capped it was keeping in mind the historical time we're at. They put an interest rate in that was real low, prime plus 1, and that's what we're at. We're at 4.25 if that's what's happened, and that's what would have happened if McBride was applied. What Judge Verdon did was she said it's the United States rule that applies, but what she missed in that United States rule is the argument that a debtor making a voluntary payment gets to call the shot on how you apply the payment. That's in McBride. It's in any number of cases that are cited in the briefs. The only cases that don't say that are cases cited by the appellants where there was no designation of how to apply the funds. If you don't accept our designation, or what we believe to be our designation as a designation, party over, send me home, throw me out the door. It won't work. But if you accept that as a designation, then we get to call the shot. If you look at what Judge Verdon did, she understood that the calculation was correct for the principal plus interest at 4.25%. She just thought that under the United States rule, the designation didn't make any difference. And if you look at her minute order on 6/2013, she basically says that. She says that the only way to avoid the rule is if you got an agreement or a statute. She doesn't recognize that there's another exception to the United States rule, and that's if the debtor designates how he wants the monies applied.
But counsel, don't we have cases that suggest that payment on a judgment is compulsory and not voluntary?
You certainly do. You have two that I'm aware of, and only two. And neither one of them involved a designation. The one that comes to mind right away is Brown. Brown was a habeas corpus action. And the guy's in jail, and what he wanted to do, he got out of jail because he paid what was due, and he wanted to fight what he paid. And the court, if I understand what they did, was they said, no, if you wanted to fight how much you owed, that should have been fought when the judgment, the case was there in principle, and that's what the issue, and that habeas corpus is not the way you do that. The other one, it was 4200 something Street, Broadway or something. I forget that, and I have to tell you, it escapes me what the actual facts of that was. I do know that it was another case where there was no designation by the debtor, no designation of a voluntary payment on how you're to apply it. That's different than what we have here. That's an exception to the United States rule. We think it should be applied in this case. In terms of McBride and the new statute and our thoughts that there needs to be some statutory construction to straighten this out, we think you've got three possibilities. One possibility is simply to say keep the old rate. If you say keep the old rate, what do we end up with? They get 10%, but you don't have a statute to pay them under, because that statute that authorized 10% went away with the adoption of the new one. It's been amended. There is no longer a statute that authorizes payment of 10% on the judgment. And McBride says, you got to have a statute. If you don't have a statute, it says that the obligation to pay interest is a statutory obligation. It's not by contract, and it says further that when the interest rate changes, the statute has the effect on existing judgments. So the interest rate changed by that statute. There's no question about that. So the other statute's gone, and so to accept we're going to rely on the old one, you're not going to apply all of the new statutes. So that, at least from my understanding, creates some heartburn in terms of statutory construction. The second way you can do it is you can adopt the enter-on language that the appellees have focused on, and you could say, hold it, that entered-on language really means all judgments entered before and up to the date. And that's just a massaging of the English language. You certainly could argue that enter-on means everything, because everything has been entered on before. That's a second way you could construe this thing. And the third way, I think, and maybe the one that makes most sense, is you can look at the judgment they've got. The judgment they've got states that it's interest at the rate provided by law. So what's the rate provided by law today? It's 4%. It's prime plus 1. That's all. That's what they argued for. That's what they agreed to. That's the judgment they got in 2009. That's what that judgment says. And now they don't want you to follow that and apply to them the interest provided by law. We would accept that that's kind of an inconsistent approach to the statute, and that when you go to construing it, the better way would be to apply it. Finally, I had one other thing, but one thing I feel I have to mention when I walked in the room, Justice Feldman handed me
Do you want to save some time for a bottle?
I do. I just wanted to get on notice my objection to his offer of what he now classifies as a factual overview that I've never seen before, bright and early this morning. And if you're inclined to accept it and look at it, well, we'd like some time to respond to it. Thank you very much. I'll reserve the rest of my time.
All right. Thank you, counsel. Counsel for the appellee.
If the court please, Stanley Feldman and J. Emery Barker for the appellees. Let me turn first, if I may, to the what I think is the core issue in this case, 10% or 4.5%. Everything else sort of revolves around there. Mr. Helm was kind enough to say that we don't want the 4.5% rate. We want the 10% rate, which is partially correct. The rest of the sentence should also say that it's the legislature that wanted the 10% rate to apply to judgments such as ours, which were entered in 2009. Section 17B of the statute, which was before the legislature and which it voted on, and which was engrossed by the clerks of the House and the Senate and sent to the governor for signature, Section 17B said simply that this change in interest rates from 10% on a judgment to 4.5% on a judgment shall apply to all judgments entered after the effective date of the statute. The effective date of the statute was July, I think, 14 of 2011. Our judgment is 2009. The very face of the statute, and he's asking you to ignore what the legislature passed and the governor signed, the very face of the statute says that the reduction in interest rate shall apply to judgments entered after the effective date, which was, as I said, July 2011. If there's a doubt about the question...
Counsel, is it in the statute, or is it
Yes.
some sort of legislative gloss, or it's in the session laws?
It's in Section 17B of what was in the engrossed version of the statute. It was thus, the procedure for engrossing the statute is the clerk of the House and the clerk of the Senate engross a statute and transmit it to the governor, attesting, in fact, to this is what the legislature passed and you should either sign or veto. And that's what happened here. If there's any doubt, the Supreme Court solved that doubt in the Metzler case in 2014. And I'll take the liberty, if I may, of quoting. The current version of 14-1201 took effect on July 2011, and it applies to, and then it quotes the statute, all judgments that are entered on or after that date, period, end quote. So the statute's clear, the Supreme Court's clear, and our position on the 10% is simply that since our judgment antedated the effective date of the statute, that we're entitled to get 10%.
Do you have a cite for your Metzler case there?
Yes, sir. Metzler versus BCI, Coca-Cola Bottling Company of Los Angeles. And then I'm sorry, what we have, because we filed our supplemental citation right after it was decided, was CV130750 PR, slip opinion at paragraph 25. I'm sorry, I don't have the reporter citation for it.
They should have it up on their website by now.
I can't even work the website for that.
So when Mr. Helms says that the old statute went away, I must beg to differ with him. It's still there. It just applies to judgments like ours entered before July 2011. It's still there. So the new rate is the law. So let me get then to the other issue. I want to make clear, because I believe, with all due respect, Mr. Helm does not accurately state our position. Our position is simple. There was not an agreement. There was not a direction as to application of the payments. What there was, he doesn't read the whole transmittal from Mr. Frizzell, who's the one who sent the money. God bless him. Mr. Frizzell was not paying just principal. Mr. Frizzell was paying all, according to his computations, every penny of all principal and interest that was due, according to his computation, at 4.25%. And we set that out in some detail in the brief at pages 11, 12, and 13. And if you look at the whole thing, and not just the part that Mr. Helm quoted, he was making, and I quote now from the email, payment of the principal amounts due to the farmers as partial assignees of the dam owners per the 1118 judgment, 111809 judgment, plus interest at 4.25%. Then he went on to state specifically that they were intending to pay the judgment in full. They never mentioned a designation between interest and principal. And so when we got the money, having reserved all rights to fight about its application to everything, when we got the money, we applied it as we were entitled to do, first to the payment of accrued interest, and then the remainder to principal. And there was never any designation. If you look at Mr. Frizzell's letter of January 17, 2013, which was Appendix 4 in our brief, he says, I am writing to all of you to respond to recent telephone inquiries. The district's position as to the unconditional tender of payments made in December 2012 and January 2013 is they represent payment in full of amounts owed regarding the portion of the amended judgment. That's what they were trying to do, pay it in full. They didn't succeed because they computed the interest at 4.25% instead of at 10%. So it was an unconditional tender, especially as to allocation, because there had never been a dispute up till that time as to allocation. That dispute erupted, if I may use the term, later. And then, to reaffirm everything, on May 28, 2013, in front of Judge Verdeen, and this I think is the basis of her order, applying the U.S. rule, we've set forth the colloquy in Appendix 5 of our brief. Mr. Frizzell said, and then finally, turning to the application of payments issue that Mr. Barker led off with. That's the first time in the record. First time in the record, 6 months after the tender funds, at which the allocation became an issue. And Mr. Frizzell, on behalf of the Flood Control District, says, so do I have an argument, Your Honor, that they agreed to this or anything along these lines? No. Okay? Then he says, no. It was the district's intention that the dispute just be about the difference in interest rates between December 28, 2012 as opposed to a dispute involving some unpaid principal in the continuing accruing of interest. And then he expressly denied any condition on the tender. There was never a direction. What I'm trying to get at is there was never a direction. I understand and we have taken the position all along that the U.S. rule is that if the debtor, Flood Control District, had directed the application of all the money to principal as distinguished from interest, then we would have been obligated to do that. Our point is simply they did not make such a direction. They were trying to pay the whole thing in full, and they failed. And having failed that, we went on and we did what the U.S. rule permits. As a creditor, without a designation from the debtor, we applied it first to the payment of interest and then to the payment of principal. And the reason for doing that is set forth in the Martin case, Martin versus Martin, that we've cited in our brief. Because if you don't do that, then the creditor is at a substantial disadvantage. Because, as Judge Thompson mentioned, who's paying interest on the accrued interest that was never paid? Then you get into this whole argument of compound interest. We didn't want to get into that. We took all the money and we applied it first to payment of all the accrued interest, got that out of the way, and then applied the great majority of the money to reduction of the principal.
I see what Judge Langford wrote was, if payment were applied first to principal, then a creditor could be left with a non-interest bearing balance of accumulated interest.
Right.
And the debtor would have no incentive for speedy payment. So I guess that's the notion that Mr. Helm was referring to.
Yeah, and that's what I'm referring to. And that's the reason for the United States rule. So let me say a word also. Mr. Helm mentioned that I was going to proffer some exhibit to the court. And actually what I have here, and I would ask leave to leave it with the clerk, is a factual overview of this case going back to the flood actually the building of Gillespie Dam in 1921 and the flood that happened in 1990. It is solely for the court's convenience because it goes back over everything that happened. Mr. Helm said he'd never seen it before, but I hope he read our response to the petition for review in the Supreme Court, because it was set forth in that petition for review, which was filed on September 24, 2012. Supreme Court got it, never made a complaint about it. He never made a complaint in the Supreme Court, and I'd like, if the court would let me, to leave 3 copies with the clerk. It just may help you go back or help the law clerks go back through. This is the 6th appeal. There's been, what, 3 trials? 4 trials? But can't even remember. 3 or 4 trials, God knows how many evidentiary hearings.
It also may be that I think at least 2 of us have been over, there's a suspension bridge, is there not? A suspension bridge near the earthen dam?
Pardon me?
There's an earthen dam that's what.
The Gillespie Dam wasn't earthen. It was concrete dam built in 1921. And it was breached, first overtopped and then breached in the flood in 1993. And what happened after that, the farmers' downstream land from the dam was inundated with 34 million cubic yards of sediment. The farmers then sued the dam owners for damages for improper upkeep of the dam. The dam owners were indemnified by an agreement that the flood control district gave them. So in one of the trials in the past, the jury decided that the cause of the farmers' damage was 10% attributable to the flood control district and 80% attributable to the dam owners and 10% to a non-party. But the dam owners had an indemnification agreement that covered that 80% that they were liable to the farmers, and they tendered the defense to the flood control district, which refused it on 2 occasions back in the 1997s or 98s, and all that's in this.
So that's how you ended up with this apportionment issue about sanctions? There was
Yes.
You had to apportion sanctions in this.
Yes,
Shifting.
and may I confess, Judge Thompson, I do not understand the whole sanction issue. It was Mr. Barker's problem. Mr. Barker started out as representing the insurers, Prudential and Hartford, and I started out, my firm, representing the farmers, and with Mr. Knurk and Mr. King, who are back there. So I have never paid much attention to the sanction issue, but I am happy to say it is not an issue in this appeal. It's gone by the board.
And we weren't on that appeal, I don't think, so we probably don't have to understand.
May I say you were fortunate. I have read the judgment on the sanction issue and still don't understand it. But Mr. Barker did, and it's all cleared up. So let me say something about mootness in this case. This amount of money that came with the emails that both Mr. Helm and I have mentioned in December of 2012 was sent as a payment intending, as I have pointed out, intended to be a payment of the entire amount owed. Not the entire judgment, because there was no judgment at the time. It was made, that tender was made 6 or 7 weeks before a judgment was entered, let alone before an appeal was filed. And our point on mootness is simply that if you pay the amount that you calculate is due before any judgment for that amount, let alone before any appeal for that amount, you have made a voluntary payment. And you have mooted the issues. And that is especially true when, as here, the judgment debtor is a public entity, not subject to execution, not subject to having to file a bond for costs or anything. The only way you can make them pay if they don't want to is by a mandamus petition to require them to lay an additional tax. So they were under no compulsion. They simply made a payment in order, as they put it, to stop the accrual of interest. And that was fine, and we accepted it, and in our view, it moots the appeal. One final thing about attorney's fees, and that's simply in their reply brief, they said that we're not entitled to attorney's fees under the statute because this is a tort case, not a contract case. Well, again, I must respectfully disagree with Mr. Helm. This is a contract case. It arose from the indemnification agreement between the Flood Control District and the dam owners. It is, and you will find in the head notes of the third and the third appeal, and even in the head note of this appeal from the prior decision in this court, a very clear statement that this was an indemnification agreement. So it is a contract case. And we respectfully submit we're entitled to attorney's fees under the statute, as well as a couple of others we mentioned in our brief. I have nothing further unless the court has a question.
Thank you, counsel.
Thank you very much.
Mr. Holm?
Sorry, John.
Thank you, Your Honors. Just a couple of comments. The first one that shocked me was when counsel indicated that there was no dispute over interest or anything like that for 6 months after the payment was made. And I would suggest to you that that's a misstatement of a fact. If you take a look at the emails that were transmitted that morning with the money, the one that's dated December 28th at 10:11, it says, the only issue remaining in the 97 cases between the farmers and district is whether the correct amount of interest was paid off. There was a dispute on the amount of interest, and that is based on what rate was applicable since day one, since we sent the first email. The first email says it's intended to cut off interest. So regrettably, I disagree with counsel when he says that the dispute didn't come up till 6 months later. It was right there from the get-go in the allocation we made of the funds. The second point I'd like to make is there's no law that says that a debtor making a voluntary payment has even got to pay all the principal. If you look, and I forget the name of the case, I apologize, but there's a case cited in there that says a debtor can apply it all to the principal, nothing to the interest. He could apply it all to the interest and not to the principal. He can apply it partially. It's up to him. If he makes it, he gets to designate it. All the arguments they're making go to undesignated funds. They rely on the Martin case. The Martin case was the case I couldn't remember the other name of. That's another divorce case. There's no designation in that case, and therefore the United States rule applied. That's simple. If you got the designation, the United States rule doesn't apply to the extent that designation is applicable. He says there's no judgment. They couldn't have known what the amount was. I must have missed that 2009 judgment that was entered. That set out the amounts. They were right there in big red bold letters. This is what the district owes on the principal. We know that. We do that number since 2009. So I would suggest to you that that's a misstatement when he says we didn't know the number to do the calculations before the Judge Verdon judgment, which was to handle some other things. They had a valid judgment in effect from 2009 when the appeal on those matters went up and came to the Court of Appeals, and you rendered your decision, and then it went on up to the Supreme Court, and they refused to accept jurisdiction. We knew exactly that the 2009 judgment was in effect. It said it. And
I mean, you're out of time. Is there something you want to wrap up with briefly to conclude your argument?
Just the last thing on attorney's fees. The tort issue, we didn't say that there was no tort. What we said was that this case arises from this appeal arises from a statutory dispute over how you interpret 44-1201. Not that it's a tort case. That has nothing to do with tort. That's our reason why they shouldn't have attorneys, or one of our reasons why they shouldn't have attorney's fees. Thank you, Your Honor.
Thank you, counsel. We will take this matter under advisement and issue a written decision in due course. Court's in recess.